Here's an example. For those of you in real estate, which I know many of you are, this first paragraph should look familiar. The second paragraph has the same legal effect, except it's only 2 lines. Let's just quickly go over it. Lessees shall use demised premises for the purpose of a general business office. Who uses demised anymore? Does anyone know what that word means besides attorneys? I just say lessee shall use premises as a general business office only. Very simple. Second part. Lessee's use of the demised premises shall be subject to the additional limitations on use contained in the following subparagraphs, or as described in this agreement. Okay? This may look familiar to you because the first paragraph is actually the standard agreement in the AIR forms. All right. So you've set up your contract agreement. You have an understanding of the minds. It's very clear and plain terms. You've got into the mind of the other party. Now we're talking about how do you avoid a dispute from escalating? Because sometimes you just can't prevent it. Sun Tzu says that if equally matched, offer battle. If slightly inferior in numbers, avoid the enemy. And if quite unequal in every way, flee from the enemy. Avoiding escalation is about stacking up the deck. Making sure that at the inception of the contract, you've already stacked it up so that if there's a dispute, there's no advantage from the other party going after you if there is a dispute. So this is when we get into more of the detail of the contracts that I think a lot of you are here to see. Attorney's fees clause. In the United States, the standard rule is that each party pays for their attorney's fees. The English rule is such that the prevailing party is awarded their attorney's fees. So now accordingly, we follow the American rule unless there's 2 instances. Unless it's changed by statute or by contract. By contract. That means that you as 2 parties willing can change the rule and start following the English rule. Now each has its advantages and disadvantages. You may wonder why we follow one and not the other. The English rule, where the attorney's fees are awarded to the prevailing party, it's designed so that it discourages litigation. But the disadvantage of that is that people that may have a claim may be discouraged from bringing it because they're worried about paying the other side attorney's fees. But then again, if they're going up against a big company, they may not care about paying the other attorney's fees because they have plenty of money. Versus the American rule, which is we want to encourage people to go to court and seek justice, even if their claim may be a little off. And so this is part of the reason why our litigation in this country is a little bit out of control. So accordingly, you have the option to, by contract, to switch to the English rule. So if you want to avoid escalation, make it less appealing. Now the problem is if you're going up against a bigger company that has a much bigger wallet than you, this may not be as much of an issue. Here's an example of an attorney's fees clause. It has a lot of defects, but I just wanted to give you a short example of that. Mediation. Mediation is very simple. It is most of you are probably familiar with this. Again, in real estate, in all your real estate contracts, there's a required mediation clause in which you're required to go to a third party, usually a former judge or an experienced attorney, to help you settle a case. Now, putting a mediation clause in your agreement, again, most of these real estate forms already have it in there, is a great idea. Why? Because prolonged warfare, no one's benefited from that. Just as prolonged litigation, no one's benefited. So therefore, mediation is an opportunity for you to settle your case early. You may not want to do it, your attorney may encourage you to do it, and you still may not want to do it, but by putting it in the contract agreement, it allows you to have that opportunity to settle the case early. So yes to mediation clauses. Now a little bit more controversial subject, arbitration. I say controversial because most business attorneys put arbitration clauses in their agreements. I personally do not. I think that arbitration, there's a myth surrounded to it, in the sense that everyone thinks that arbitration is automatically better. My position is that it depends. Why does it depend? Well, Some people say that it's cheaper. Well, not necessarily, it depends. Another thing is that it's not appealable, meaning that the decision of an arbitrator, by the way, just to understand what arbitration is a private court system in which you pay for, in which is out of the regular public court system, and in which is binding. And not only binding, but if they make a mistake of law, it's not appealable. Now, appeal is very expensive in the regular court of law, but my thing is why make the decision beforehand? Why make the decision not to appeal before you even know what the case is before you? Third, questionable objectivity. Arbitrators are chosen by people like me, your attorney. And when we choose an arbitrator, we're going to choose an arbitrator that we've used before, that we receive favorable results for. So this is my cynical point of view, but I just think there's questionable objectivity. Next, the duration of the arbitration itself. Negligible difference. Some people say it's automatically shorter. Again, not necessarily. Real estate, it's probably pretty short. Lack of transparency. And lastly, because there's a myth that arbitration is better, it may actually encourage litigation, which defeats our purpose of avoiding escalation. Now, I did say I don't use them, but I actually do. But here are my factors. I use them when my client needs a private proceeding. For example, we have a client up in Los Angeles that services celebrities. Now, if they have some kind of dispute with one of their clients, we want to make sure it's under wraps. Second is if I have a client that is contracting with somebody that they have a huge upper hand over. For example, an employer versus an employee. As I discussed before, arbitration can be more expensive, specifically in the initial filing fee. And so therefore, if I can make it more difficult for an employee to file a claim against the employer or my client, then arbitration might be a better option. Second, third is client preference. Some clients just have experience in arbitration, and so therefore it's a better fit for them. If you are situated at a great distance from the enemy and the strength of the two armies is equal, it is not easy to provoke battle. Very simple. If we're going to fight on our home territory. You guys have probably all seen these clauses, but fighting in your hometown is your advantage, and your advantage is the other party's disadvantage. You want to make it difficult that if you contract with somebody in Alaska, that you don't have to go all the way over there to litigate. You want them to come down here. Why? Well, you know the lawyers in the area, no travel cost. I think this is obvious. Now, I'm rushing through this because I wanted to get to this slide right here. This is probably the most important slide in my presentation. Indemnification clause. It is the most dangerous clause in any agreement from a general perspective. I implore you that it must be reviewed by an attorney to really fully understand. But I'm going to attempt to try to explain it to you so that maybe you can start taking a look at the contract agreements that you're signing. What is an indemnification clause? Simply, the purpose of the indemnification clause is to allocate risk. You're trying to allocate risk of the person that is in the best place to diminish the risk. So that means basically if I contract with a contractor to build a ladder for me, and I want to make sure that if I use a ladder somewhere else and someone uses it and gets injured and that person sues me, that I'm going to have that contractor that made that ladder indemnify me so that I'm not damaged by that. That's an example. But you have to look, again, looking to see, thinking about how to negotiate in a cooperative manner to make sure that these indemnification clauses are fair. What's the test? The test of fairness is, does the clause allocate risk to the party whom is in the best position to prevent the risk of loss? Think about that for a second. Allocate risk. Let's take a look at an example of indemnification clause. Looks like my logo's blocking it. Let me just... I know I'm vain, but I'm not that vain here. Okay, contractor agrees to indemnify and hold harmless company of and from any and all claims, demands, losses, causes of action, damage, lawsuits, judgments, including attorney's fees and costs, to the extent caused by or arising out of or relating to the work of the contractor. By the way, this is a simplified version. There's a problem with this. The question is, does this allocate risk to the person, the party, who's in the best position to prevent it? So what is the defect in this? Anyone have any idea? Just raise your hand. The problem with this is that last sentence, or that last part, last two lines. To the extent caused by or arising out of relating to the work of the contractor. Caused by, I get. If my contractor makes a mistake with their ladder and causes injury, then yeah, it makes sense. They should pay for it. But arising, relating to the work, that means the contractor may not even be responsible, yet he or she is on the hook. So simply cross that out. Now, indemnification clauses are very difficult to read, so you have to break it down. First, you look, who's indemnifying whom? Be very careful about mutual indemnification clauses. I get this all the time. I review a contract, I send it over, and the other attorney, other party, why don't you make this indemnification mutual? Many of you may have heard that before. But to me that doesn't make sense. I need actual language. You can't have each party indemnifying the other for everything, then it's just an infinite loop. You need to be specific. What kind of losses will be covered? Negligence, intentional torts, fraud? Who controls the legal strategy? Now, do I get to choose my attorney, or does the contractor? What triggers the indemnification clause? When I get sued? After a judgment's filed? When I receive a demand letter? Is there a duty to defend? This is an important one. A duty to defend means that if the contractor has a duty to defend, that means they have to pay cash for my attorney's fees at the inception of the lawsuit, as opposed to you just pay me if I lose and after the fact. It's a big difference in cash flow, right? Lastly, insurance. You need to make sure that whether you're being indemnified or you're indemnifying somebody else in contract, that you're properly insured. And you can require this in the contract agreement. All right. Running close on time here. I want to give time for questions in just a second. So, lastly, you've done your job to prevent a dispute from occurring. You've done your job for avoiding a dispute from escalating. But how do you win? The reality is winning is the easiest part. Because if you've done these two things already, all you have to do is perform. And if once you perform and you get sued, then you can let the chips lie and see where it goes. And if you prevent it and avoid it, you're done. This is the art of contracts. Okay, let's open it up for questions. I know you had one back there.
Yeah, if you've got a contract and one of the parties is...
You may want to wait for the mic so everyone can hear you.
Oh. If you have a contract and one of the parties is required to pay legal fees, say A is to pay legal fees of B, is that reciprocal in the contract when that's established? Is that still that way?
Sure. Very good question. So just to repeat the question, his question was, if you have a contract agreement with an attorney's fees clause and it says party A is going to pay party B's attorney's fees in the event of some dispute, is that now made mutual? Or that's the question, right? So the answer is, in California, the law is that it's automatically made reciprocal. But that's a state law. If you recall, one of the slides was about venue and choice of law provisions. Again, another important reason to pick a state that you're familiar with in law. And so if you have a clause in there that the state of California law applies, and you have an attorney's fees clause that is only one-sided, state courts will automatically make that mutual. Good question. Any other questions? Please.
This is very specific to investing. Oh, thank you.
Uh-oh.
I think that's what we're all here for. So For example, I've been a second lien holder on a property, and
I'm sorry, second.
I've been a second lien holder on a property, and later found out that the borrower was not paying the first lien holder. And I didn't find this out until closing, so luckily we found out in time. But what kind of language can I put in the contract, whether it's a joint venture agreement or a trust deed, to make sure that I'm alerted to the fact that it's not being paid, or what recommendations do you give?
Yeah, that's an easy one. You put that exact language in the contract agreement. I know a lot of us, especially with these form contracts, are hesitant, especially without an attorney, to put our own language in there. But besides all this legal stuff that I mentioned, it's very important just start putting in the terms, and I know this is coming from an attorney, it sounds weird, but put in the terms that you want in there. If you want that party to notify you if the borrower stops paying, add it to the agreement. Very simple. But you have to contemplate that beforehand. That's the hard part. That's lawyering. Lawyering comes with experience, and I know a lot of lawyers will tell you never do anything without an attorney. My position is, look, you can, but you can't compare the experience to an attorney. They know what to look for. They know what to come up that may come up. And I have clients that are really good and have a huge number of business experience, and you can see it out in them that they're able to negotiate their contracts very well. Yet they still send it to me, but the point is that they're very competent. So I would just put it in there. Hopefully, does that help? The first lien holder. You're not contracting with them. That's true. I don't know the answer to that question, actually. That's a good question, because let me think about that. I don't know who's. I think I saw that hand first, and then you two. Oh, do you know the answer? Go ahead.
A partial answer, anyway, is your clause is a second lien put in there that if anything gets filed by the first lien.
Well, that's different, though.
That's a little bit different.
After things are filed, that's yeah.
That you have to be notified, so that is after the fact.
Yeah.
Right.
Yeah. So he was just saying after notice of default's filed, then you can have it so you're notified. But I think this is the moment when the borrower stops paying. Yeah. But yeah, probably. I don't know. That's a good question. That's kind of out of my element. So you had a question back there?
So if you are starting out and you want to make sure that you have all your contracts correct, should it be a thing where you go to a lawyer and say, what contracts do I need that you know, and pay for those all to be done so that you'll just have them on file to use? Mm-hmm. Or should it be done in a case-by-case basis?
That's a tough question, because I think it depends upon your budget and the variance in your transactions. I would say that from what we do as a firm, we usually represent our clients as a general counsel, and we maintain a very long-term relationship with our clients. So for our clients, it doesn't really matter, but even then, we still end up creating templates that they're going to be using often. And unless there's some major modifications, they don't usually call us on those particular agreements. So if you are in a business in which you have transactions that are replicated, then it's very feasible to just have a template drawn up for you that you can reuse. And a competent attorney will be able to advise you accordingly to that. And obviously, we didn't do the disclaimers in the beginning. I'm not going to give specific legal advice. If it gets too specific, then you can always contact us, obviously. Absolutely, no, that was just a disclaimer afterwards. So, yeah, please. I can repeat it.
Okay.
Yeah, go ahead.
I have a private investor that I'm working with right now. We were submitting a purchase agreement through a broker for a commercial property, and the broker came back and said it's unacceptable. We have to use this state's specific form to purchase it. Is that true? That there are some states that require specific forms for their purchase agreements? Commercial property.
Well, I want to say no. I'm not familiar with any state's regulation requiring a specific contract. Even the car forms, you can edit as necessary. So unless it's a particular state that I'm not aware of, I know California is not like that, so that seems odd to me. Here's another thing is that when it comes to venue clauses, I try not to negotiate that out. In other words, for me, it's very important that we get the law, California law, applied, because if another state's law is applied, not only is it going to cost more for my client, but there's risk involved in that we're working with another state that we're not familiar with, and it may have weird laws and like that we not, we may get blindsided by. I've never heard that. Again, not specific advice, but any other questions? Okay. All right. Well, thank you so much. By the way, just introduce. Thank you. Introduce my another attorney is Matt Staub. He's up in front if you have other questions. He specializes in tax, business succession planning, and really appreciate your time. Thank you, Reggie, and the other organizers for inviting me. Thank you very much.